Yes, please.
Okay, thank you. So, good afternoon, everyone, and thank you for joining this call and for being here. I believe you are only seeing the slide, right? The presentation.
Yes,
yeah. Oh, okay.
Yes, please.
So I'm going to make a presentation about the current regulatory landscape throughout the world, a little bit throughout the world, and then talk a little bit more on Europe, on the European Union, talk about the AML 50 directive and the market in crypto asset regulation, which will bring a lot of comfort and a lot of consensus into our regulations and to our law in the European Union. So I'm a lawyer in Quatro Casas. I work in Portugal, which is a small country in Europe, on the eastern side, on the western side of Europe, the most western country in Europe. And I've been studying this fascinating world of blockchain technology, crypto assets for quite some time already. So thanks for being here. So let's move forward. So into the summary, we'll make a brief travel around the world, visiting some jurisdictions and their current regulations regarding virtual assets, ending the journey in Europe and pointing out to the near future in terms of virtual assets regulations here in our jurisdiction. So entrepreneurs are sometimes unaware or detached from the legal aspects of having a company. But they are of the utmost importance either as to set up the activity or to avoid future problems with compliance in any way. So I hope you enjoy it as much as I enjoyed preparing this presentation. I will try not to be just another lawyer talking about lawyer things and be tedious. So please intervene if you want, make questions. I'll try to address them or save the questions for later on, and we can go through them as a whole, as a panel. So, yeah. So I believe it's always useful to start this journey into crypto with some fundamentals. And reading Nick Szavo's works about smart contracts, or David Chaum about cryptography and anonymity, Ian Grigg about the Ricardian contract as well. It's always useful to understand from where we came. It's very useful to know to where we go, to understand from where we came. So I really advise you to read some of the things that Nick Szavo, David Chaum, or Ian Grigg wrote on these regards. So I really recommend to everyone to dwell into these building blocks in order to understand what led us to the now quintessential work of the entity known as Satoshi Nakamoto, who created the Bitcoin blockchain, which was the first blockchain that existed. So a lot of things that were already thought at that time, back in 2008, were designed and discussed before by the guys that I've mentioned. So David Chaum, Ian Grigg, Nick Szavo, Wei Dai, Adam Beck as well. They all led Satoshi Nakamoto into develop whoever it is. I don't know if it's an entity or a group of persons, just one guy or a girl, but all these people before, they all led into the creation of the Bitcoin blockchain, the Bitcoin code, and that was a major breakthrough in the day, and it still is a big breakthrough in terms of technology. So I would also like to point out that when we talk about regulating blockchain, we normally refer to regulating activities with cryptocurrencies or crypto assets, because as you already know, blockchain is just a type of distributed ledger technology that can assume many different forms and use cases. So nowadays, even if we talk about decentralized ledger technologies or DLTs, the biggest use cases are mostly financial. So we always end up talking about NFTs, crypto assets, cryptocurrencies, virtual assets, any type of form that you want to describe the tokens that are created within any type of blockchain. But there are also the distributed ledger technology, which is another way of designing or of describing a specific blockchain. But most of the times they are permissioned blockchains and not permissionless blockchains. The difference is in a permissionless blockchain, it is a public blockchain, everyone can adhere to it, can make transactions within that blockchain without some entity that controls that blockchain needing to allow someone to enter in that kind. So the kinds of blockchain with the most immediate impact in our daily life are usually those that have a direct influence in our wealth. So hence our big focus on tokens that may have some kind of a fiat convertible value. So cryptocurrencies and blockchain have been around for a long time, but within the past decade, they have propelled into mainstream acceptance and adoption as not only alternative forms of payment for individuals, but also time and cost savings for a multitude of enterprise applications. So one driver for the first widely adopted cryptocurrency, Bitcoin, was to create some kind of store of value that existed outside of a specific government control. It is therefore no surprise that attempts to regulate the rapidly developing crypto asset market have required great efforts from regulators and legislators around the world to keep a pace or to adapt to this whole new reality. So after the launch and success of cryptos like Bitcoin, Litecoin, Ethereum, and more, other cryptocurrencies soon followed, thousands of them. So there are like 8,000 different types of tokens, each one with a specific purpose. Some of them don't have a purpose at all, but are just meme coins like Dogecoin, which is a token that Elon Musk likes a lot. He says that he has some, his son has a lot of Dogecoin as well. So he is always trying to make some funny memes with Dogecoin. But in the end of the day, the technology is very basic and it doesn't have any real value attached to a Dogecoin. But anyways, people believe that the Dogecoin has value, so it's transacted in the secondary market with some value. So actually, if you guys all check CoinMarketCap, which is a website that allows you to see all kinds of tokens that are sold or transacted in the secondary market, in a centralized exchange, or even on the decentralized exchange, the well-known DeFi, you will see that there are at least like 4,000 different tokens with a varied amount of value in each one. So regarding virtual asset frameworks, I would like to share the idea of a recent book that I've read from Anu Bradford that it's called The Brussels Effect. It is a very good book as it reveals the European Union unique power to influence global corporations and global citizens and set the rules of the game, which later on are copied by other jurisdictions. The European Union can exert global influence across diverse policy areas, from data privacy and consumer safety to environmental protection and competition rules. So under the European Digital Finance Strategy, the European Union is now promoting the regulation of the crypto assets market. And all across the globe, we are seeing governments trying to tackle through pinpointed and targeted legislation, the advent of a decentralized financial market that doesn't sleep or close during the weekends. It's easily available to every retail investor. This is very useful to the African continent as a mean to achieve some sort of financial independence or financial proficiency in that kind of way. You have to be careful with the so-called scams and rug pulls. So we always advise everyone as being an unregulated market right now, but we always advise everyone to do a thing that it's called DOR, which is do your own research. We advise everyone to read about the project, to see if the project has a team, a coherent team, a team with people that you can look up on LinkedIn, with real people. And it's not just the rug pull project in which they launch the token and then they get a lot of money and then they destroy the smart contract or keep all the money for themselves and the token has no useful purpose. So it's always advisable to investigate before you buy any token, to investigate and to see what to do in that kind of way. So I present you, I believe you all can see the slide. It's perceptible. Yeah. Okay. I present you a little bit of the major frameworks that exist nowadays. So the European Union, the UK, the US, Switzerland, Australia. So it's a little bit of information regarding the actual virtual asset frameworks and how these jurisdictions are tackling these situations. I'll then talk about. I will next talk about some specificities in countries. So I start with the Central African Republic because it's very important to mention this because it was a very recent decision. They adopted Bitcoin as legal tender. What does this mean to adopt some currency as legal tender? It means that if you go to Central African Republic and if you want to pay with Bitcoin, any merchant or any service provider will be forced to receive that payment in Bitcoin. That's what means to be a legal tender in a specific country. Here in the European Union, we have a treaty that specifies that the only legal tender is euros. So no one can refuse to accept the payment in euros, but they can accept the payment if they want at their will. They can accept Bitcoin or any other type of currency, dollars, whatever it is. So, but the thing is, being a legal tender is that you can't refuse to accept that currency as a payment for anything. We had already El Salvador as the first country in the world to adopt Bitcoin as legal tender. Now we have the Central African Republic. So it is a major breakthrough for the whole continent of Africa if other countries will adopt the same strategy. They also have plans for a legal framework around the use of cryptocurrencies. The point here, or the thing to make a remark here, is that only about 11% of the population has access to internet. So this might be a little tricky to implement in the country because you need a wallet, you need to have to access that wallet and to control your assets. You need internet for doing that. So it might be a little bit trickier for the Central African Republic government to implement this new adoption of Bitcoin as a legal tender. So I believe Nigeria's central bank barred local banks from working with cryptocurrencies last year before launching its own digital currency, the e-Naira, but they will adopt it. A CBDC or a central bank digital coin is not really a crypto asset per se. It's just another way of having electronic money because it's centralized, it's controlled. A lot of times it doesn't really work on top of a blockchain, of a permissionless blockchain. So it's kind of hard to define CBDC as a crypto asset. But in any way, they are launching their own digital currency in Nigeria. And South African regulators also have been exploring the potential regulation of crypto assets and cryptocurrencies and the blockchain technology. And Tanzania's central bank said last year they were also working to prepare a presidential directive to work with cryptocurrencies. So to address Brazil, a lot of bills are being discussed at the National Congress. They have specific rules that demand investors and exchange to provide information to tax authorities. So they are already taxing cryptocurrency exchanges. Open banking and instantaneous, they have an open banking and an instantaneous payment system called PIX, which is very avant-garde for their criteria. And they also have sandbox programs for fintech where companies can develop a lot of products without the regulatory restraints that they would have if out developing those projects outside the sandbox program. So it's a country that is developing a lot of infrastructure and a lot of information and projects within the crypto space. China, as you know, they have banned initial coin offerings back in September 2017 until very recently, and I believe it's not illegal to buy, hold, or sell cryptocurrencies, but the exchanges were banned and the proof of work mining of Bitcoin was also banned. But I also have sizable investment funds that invest in this area. So it used to be a country that were trying to develop this ecosystem, but once they decided to go on the route of their own CBDC, they started to ban these companies or these activities from the mainland. But there are a lot of Chinese people with a lot of cryptocurrencies, and they were one of the major countries investing in this area. Singapore is a very important. It's very important to mention Singapore because they had a big emergence in the recent years as a global hub in technologies such as cryptocurrencies and blockchain. The Monetary Authority of Singapore has been taking steps to actively regulate cryptocurrency business in Singapore as well. So they offer a neutral regime for the growth of transactions involving cryptocurrency. So it's a good country to have in mind within this system. The United States of America. I believe my colleagues Nicole and Joanne will address this topic, but just to give you some points, initial points on this. A lot of the ecosystem and the key players, the original key players of the blockchain ecosystem started in the United States. They are one of the major countries with people investing in crypto assets. The biggest companies come from there, apart from Binance, but Coinbase, Anchorage, FTX, a lot of companies were based there or started there. So they have Kraken as well. It's a major centralized exchange, well known. They all started in the US, but recently they are tendentially trying to seek other jurisdictions because the US is increasingly regulating the crypto space, and not as always in the best way possible to do it. But I'll leave that for Nicole and Joanne. They are more endowed to talk about the US on this specific. So the European Union, the overall approach of the European, yes.
Sorry, do you mind just talking to the public, to the audience, a little bit about the cases that you quoted on the previous slide?
Yeah, so the SEC versus McAfee versus BitMEX and Ripple.
Right, just like a little snippet so that the audience can have a small overview about how the US is currently handling the lawsuits in this space.
Yeah, so in October 2020, it started with a lot of high-profile enforcement actions regarding the crypto space. The SEC charged the now late businessman and computer programmer John McAfee for promoting investments in ICOs to his Twitter followers without disclosing that he was paid to do so. So the SEC chased John McAfee and promoted a law enforcement action against John McAfee. Regarding the BitMEX, the CFTC there was a federal prosecution against BitMEX as well. And the SEC, but in the BitMEX case, they failed to limit money laundering and other illegal activities to its customers, despite being aware of such activities. So it's the CFTC prosecuted BitMEX. And more recently, which is still ongoing, we have the case of the SEC, the Securities and Exchange Commission, against Ripple Labs, because they considered that Ripple was a security token, and therefore they were obliged to have to be treated as to treat the XRP, the token from Ripple, as a security token, which would require that they would have to make a prospectus and to treat such token as a security, which they didn't do it before.
And if I may add also, some of the fees, some of the penalties that the U.S. is currently imposing, if I'm not mistaken, McAfee had a $23 million penalty. BitMEX is going for $50 million, and Ripple is going for $1.3 million. So the penalties that the U.S. imposing are no joke. They're pretty substantial.
Yeah.
On a global spectrum, not so much. I mean, the money that's being invested is a lot more than what the penalty is, but the U.S. is just trying to regulate somehow, and they're imposing substantial penalties so that, you know, corporations and individuals try to follow the law. Now, this is somewhat troublesome because we don't have a clear guidance from the United States legislation as to how to behave in this space or how to conduct business in crypto and in all this new era. So
yeah.
One side note to continue, Nuno.
Yeah, thank you. Yeah, but on the other hand, in the United States, we also have a crypto banking license already. We have Kraken with a crypto license it's a chartered license from the state of Wyoming. And on the other hand, we also have Anchorage. They have a license that is a little bit more broader as a crypto custodian. They have a license given by the controller of the currency, the OCC. So they are a federally chartered digital asset bank. So they can operate in the whole United States as a bank for that purpose. I just mentioned Anchorage because it was co-founded by a Portuguese guy, Diogo Monica. So I always like to make that remark due to patriotic issues from my side. Yeah. So moving forward to the European Union. As I said, the overall approach of the European Union towards blockchain technology has been very positive and welcoming, but only recently they put forth official legislation to regulate it. So back in 2020, the European Union signed the fifth anti-money laundering directive into law, marking the first time that cryptocurrencies and crypto service providers fell under some regulatory scrutiny in a broader and wider sense within the European Union. So if you want to register as a VASP, as a virtual asset service provider in any European country, a member state of the European Union, you have to apply for a VASP registration before the local central bank or the local bank controller. And basically the types of services that are regulated for this purpose is to make exchange of fiat currency for crypto, or crypto between crypto, to make transfer services from wallets to wallets, or make custody of virtual assets on behalf of clients. So if you do any of these type of activities, you have to register before the central bank, and you need to have a big compliance mechanism implemented in your company to do it so. So I also want to talk about the main takeaways from the AML5 fifth directive. So basically was that you have to identify your clients, you have to identify your customers, you have to identify the transactions. You need to address all the porous AML QIC process that you have. You have to clean that out from your company, and you have to address them all as to provide these services. So the European Union tried to tackle all these issues, obliging every entity, every virtual asset service provider to have strong know your customer and know your transaction measures implemented. So I'll try to move forward with a little more speed, as to have time to talk about everything and to give space to the other panelists. So in the near future, we will have the Markets in Crypto Assets Regulation, the MiCA. The MiCA regulation, as it stands, numerous activities regarding the supply, purchase, exchange of cryptocurrencies and crypto assets often fall within the regulatory cracks across the European Union. So different countries tendentially try to address these issues or to tackle cryptocurrencies in different ways, and the regulation in the European Union is a law that applies to all member states as equal. So every member state will have to abide to the same set of rules. That's what the regulation intends to do. By doing so, and while there is an acceptance that certain crypto asset related activities are captured by exiting e-money regulations or by the broader regulation of the EU financial markets on the issue of securities, the MiCA will have a detailed and tailored regulatory regime for the crypto assets. So this regulation seeks to address all these issues that I mentioned with a new comprehensive framework. And it's set to start in 2000. It's set to be launched into force in 2024 or beginning of 2025. They also define the types of tokens that exist. It helps to define them in the traditional commerce, so it gives more clarity on that. They define the utility tokens, what is an asset reference token, what is e-money tokens, the so-called stable coins. They give definitions on these issues, so it's very important. This is a very important regulation, and that will make school to every other country that wants to interact with a member state of the European Union. So thank you for watching this presentation. Feel free to add me on LinkedIn and to contact me if you need any more clarification on these issues. I tried to make a short presentation. I had a lot more to say on each topic, but our time is running low, so we'll have to address other issues and to talk about what is Web3, what is an NFT, a non-fungible token, the problems of dealing with crypto assets. So I'll pass the ball to the moderators and my colleagues on the panel as to address all these issues as well. Thank you.
Thank you very much for that presentation. We're going to have a co-moderator, the person of Tato Lilian. So she's going to do justice in terms of gathering questions from participants to ask the guest speakers. I believe we have the next speaker who's going to go up next.
Yes, so if I may follow up after our colleague Nuno. So good afternoon or good morning, everyone, wherever you are. My name is Nicole. I'm a crypto attorney. I formerly worked at a patent asset management as litigation manager. I am now a solo practice. I opened my law firm and I dedicate myself on dealing with everything that has to do with Web3, maybe NFTs, DAOs, DeFi companies, startups, or any other Web3 legal issue. So because this audience, this webinar is oriented to law school students, I would like to make an overview of all the legal aspects that there are currently pending and becoming a bigger issue throughout time that you all should need to be wary of. And if you want to become an attorney in the space, you need to start learning now, because this ecosystem moves as fast as the internet moves. So you go to sleep and NFTs have mutated. Like they're a different monster, and this is overnight. So let's start with NFTs. NFTs are digital assets that have a unique encoding, like Nuno explained. They have a smart contract attached to it. Some of them may look similar or even the same, but they're unique digital assets. And what makes them unique is the encoding that they have embedded within their smart contract. So the fact that it's a non-fungible means, for example, you have a $5 bill. This $5 bill is fungible if you put 5 singles. But what is not fungible is a $6 bill versus another €6, right? They're not fungible. They're both currency, they're both money, but they're not the same. They don't have the same value. They are unique to its own, right? So this is what NFTs are. They're digital assets that are unique to the space. Now, there's a big issue when it comes to intellectual property and copyrights. For instance, Bored Apes, they have, I think they're one of the few NFT projects that they give all IP and copyright, all intellectual property and copyrights to those who own their NFTs, meaning you can commercialize however you want, to whomever you want, in any way you want. But there's other NFT projects that have a cap. Say, okay, you have an IP right, but you have a commercial value cap of $10,000. So as soon as you reach this cap, you can no longer continue commercializing. So that's where your IP rights stop. That's where your copyright stops. And you have to be very careful when you're running a project or you're advising on a project to see how to better address this, because what's hard to tell is, say someone meets this $10,000 cap. Now, how are you gonna find recourse if you don't know who that person is? You have a wallet address and that's pretty much it. You don't have an identity, you don't have a jurisdiction, you don't have pretty much anything to go from. You can summon Punk 99 because, you know, where the hell is Punk 99? I don't know. And what jurisdiction is it from? Like whose jurisdiction was it when the purchase became effective? And now what happens if that person is no longer active in the wallet or no longer having any digital presence at all? That makes it challenging. So that's where attorneys may come in place and try to figure out what jurisdiction to use. Like Nuno explained, he had a beautiful map with different countries who have different jurisdictions and they have different procedures to follow, different regulations. So not all countries are familiar with other countries' procedures in the crypto space. For instance, the United States is one of the most, I could say, I'm not sure if aggressive is the right word, but it's one of the countries that is more strict about the regulations, about the way we behave in the space. And for instance, the UK has a lot of, the UK is more friendly when it comes to, say, DeFi's, for example, than the United States is. But the wrinkle comes when this transaction touches US jurisdiction, meaning if you have a company, you have a DeFi in the UK, but the founders are US-based crypto funders, then you now have to comply with Securities and Exchange Commission procedures and regulations. And at the same time, where the UK does not have that type of regulation, you still have to be compliant in both jurisdictions at the same time. So that's something to be wary of, something that a lot of attorneys in the space are dealing with. You have to be very creative as to how to comply with both jurisdictions, how to go about a jurisdiction like the United States is still trying to get, wrap their head around how to regulate this. Now we have the aspect of the metaverse. The metaverse is a virtual reality where you can interact, you can commercialize, you can transact like if you were in the real world. Like we are in the metaverse right now, right? We're communicating immediately. We're doing, we're having something that is a utility, meaning the education, transmitting education, informing each other. This is the metaverse, right? We're all in the virtual space at the same time doing X or Y activity. Now, the problem comes with real estate. Real estate is a hot subject in the metaverse. Why? Because if you say right now, Steve Aoki has a property in the metaverse. Snoop Dogg has a property in the metaverse. So you come, say comes Nicole, and I want to buy a property next to Snoop Dogg's house, right? Fine, you buy your property, but then someone comes and puts a toxic plant next to my house, and in the middle of that, in the middle of Snoop Dogg's house, and in the middle of my house. So people in the metaverse, although they cannot smell the toxic plants, it works the same as in reality, where your property value declines and your property is no longer as valuable as it used to before this avatar decided to put a nuclear plant next to your house. So the question comes, who do you go to? There's no property registry. What jurisdiction do you apply? This is the metaverse. Snoop Dogg can be in China for all that you care for. I'm in the US, and the person in the nuclear plant can be in the Philippines. So, I mean, and this is hard to tell. So, I mean, you can definitely track where every person is or every avatar is, but at the same time, it's like, who do you go to? You know, can you take this to court? The court doesn't recognize digital real estate because it's not registered anywhere other than in a blockchain. And then the blockchain is kind of jurisdictionless, to put it that way. So that's another aspect to consider. That's just like rubbing the surface of what there is in the metaverse. There's a bunch of other legal encumbrances that are happening that it's hard to take to court, because imagine this. You come to the Supreme Court, you have a judge, and this judge is new to all this. The judge knows how to open his email, but he has a hard time finding the attachment on the email. And you're coming here telling the judge, hey, put this Oculus on and come into my virtual reality and see where this nuclear plant is. The judge is gonna tell you, no, I'm not dealing with that. And I don't care what the Oculus is. I care what's in the real world, like what I can see with my bare eyes. So it's hard to teach a judge who's used to traditional legal precedent to analyze this type of cases. But this is where law students come, right? We are the generation who's trying to create precedent, who's trying to educate everybody in this space, including our legislative body, including our Supreme Court, about how to take this, how to consider it, how to address it. You know, it's a matter of this is not business as usual. This is a new era. And this is the first time we're seeing two generations moving towards a new economy. You got millennials and you got Gen Z, Generation Z. So this is the first time you've seen two complete generations moving towards the same economic era in the same way and in a way that's never been seen before, because technology hasn't been so evolved as it is now. And this is all was, parting from the pandemic. We were all forced to do virtual reality, whether we liked it or not. The courts were forced to take hearings online, which before at the American Bar Association, it was against the rules of ethics to even have a Dropbox. So imagine that. Imagine that if having a Dropbox was against the rules of ethics. And now we've come to having hearings, virtual hearings. We've come very far in a very short period of time. So as law students, as a young attorney, I'm telling you, this is the moment where you guys are creating precedent. You can even help draft the legislation. And it's a space that is scary. I'm not gonna lie to you, because it's so novel. But there's attorneys like Joanne, like Nuno, that we may not have the life experience that they do have, but we can both benefit from each other's knowledge. And I think we're all very reachable, very friendly in this space. And this is how I've learned. I've spoken with older attorneys, I've spoken with teenagers, I've spoken with people who are my generation, and we're all learning through the process. Now, let's change of subject. So we spoke about NFTs, we spoke about Metaverse. Now we're going into DAOs. What are DAOs? So think about DAOs as a way of corporate structure, but this is a corporate structure that is decentralized, meaning there's no government entity regulating it, and there is no specific jurisdiction that runs it. There's also no board, there's no stocks, and there's no head of the corporation. What you have is called members, and these members are admitted depending on how much cryptocurrency they have invested in the DAO. So the DAO is like a digital corporation. The problem with the DAOs is that as a digital corporation, you still have liabilities, you still have responsibilities, you still have money at stake. But if something happens, who's going to regulate that DAO? You know, under what jurisdiction? Again, you can have people around the globe joining the same DAO, making transactions around the globe. And if someone has a shady move, someone steals money from the DAO, someone does some illicit activity with using the DAO, it's really hard to find recourse. So as an attorney, I advise to always, so for instance, in Wyoming, the United States, it is the only state that actually recognizes DAOs. So you can register DAOs in Wyoming in the United States. And I always recommend this to be done because it's the only way you can get recourse in case someone goes rogue or in case someone wants to be shifty about what they're doing. And the idea of being decentralized and to be independent from the government and to have no government bureaucracy involved, it's so well and good, but at some point, you still have to be a law-abiding citizen wherever you go, wherever you're transacting. And you always want to make sure that what you're doing is clean, is transparent, and there's a lot of legal encumbrances surrounding the DAOs, treat it as if it was a LLC, a corporation, whatever you may call it. It has a lot of legal issues that people are not aware of just because they think that they're decentralized. There is the misunderstanding that you can do as you please. So that's definitely not the case. And to close up, just a note as from a younger side of the attorney community, this is a space that first, it caught my attention because a lot of times, oftentimes, the younger the attorney is, the less credible they tend to be seen. But in this space, it's the opposite. It completely flipped, right? The younger you are, the more credible you are because the more likely you are to understand the technology. But on the other side, you also have experienced attorneys, senior attorneys who probably have some knowledge, but at the end of the day, you need to reach out to them because they have the life experience. They've been in the field longer than you have. And it's a beautiful combination when a young attorney who's in the crypto industry, like myself, talks with someone who's probably, more senior than me, and we start sharing ideas, doing arguments back and forth. Like, I believe this should be done this way. This other person says, but it's always been done this way. And then I come back and say, yeah, that was the old way, but how do we regulate this if it's not regulated? Under what jurisdiction? It's just a fascinating argument that goes between two legal minds. And if you're into the space, you need to get started. Put 2 hours a day, 3 hours a day, just reading, because the first criticism that I hear from clients or potential clients is, I spoke with an attorney who was a 500 plus law firm, and they made me feel like I was stupid. Like, they wouldn't understand me. They wouldn't know why I would pay so much money for a JPEG. And I need someone who actually understands my language, my world. So knowing the language, understanding the world, understanding why an ape is so valuable, why a Cryptokitty is so valuable versus any other NFT, what gives value to the JPEGs, what gives value to the community, what goes in the metaverse, what business are surrounded by DAOs, DeFis. This is a new era. This is like having a parallel world within reality. And you need to understand that if you want to get into this space.
Thanks, Nicole. Mimi, is it okay for me to jump in?
Sure.
Okay.
Yeah, you could jump in, yeah.
I don't have a formal presentation. I'm grateful that my colleagues created a good foundation for us. What I want to do is largely, I really want to encourage everyone to jump in, share what you're thinking, share your thoughts. I'm a mom, and my daughter is in college, so not very far away from where some of you may be. And I'm just thinking about what it felt like for me when I was at your stage in my career. And I was making a decision to become an intellectual property attorney. And this was in the late 90s. And I was thinking to myself, well, I don't see how intellectual property is going to be any less important in the future. And that was a pretty good bet. And I'm feeling that same way again here in the space of Web3. When we think about the tent poles of what we're going to be doing with this technology, one of the reasons I have confidence to be in this space is because I'm taking over 20 years of experience as an intellectual property attorney on a global basis. I manage IP portfolio in about 140 countries. And so I'm looking at all of Web3 and thinking, what we have is IP. On a more personal note, why I'm involved in this space is because I really think that this is going to create more opportunities for egalitarian IP-based wealth. So what does that mean? That means, in my mind, talent is indiscriminate. Talent exists all over the world. Creativity and innovation exist all over the world. Where there's a need, there's someone with a brilliant mind trying to find a solution. And what I appreciate is a knowledge that here in the United States, where I'm seated, as well as in so many countries around the world, there are people who are unbanked and who have not had access to traditional and legacy financial systems. And what this digital asset age, including cryptocurrency, is doing is it's creating a chance for people who have internet access to start to get involved, to meaningfully participate and be financially rewarded for that participation. You know, one of the things when we think about the legacy system that we're coming from, you had Web 1, and I'm borrowing from Chris Dixon here at Andreessen Horowitz, but you had Web 1, which was in many ways just a digital magazine. You know, you could take something that used to be a physical newspaper and you could make that an offering online, right? And at that early stage, people didn't really see the full promise of what the internet was going to offer and allow. Then we had Web 2, where we went from just read to read write. And we had the mix of mobile, which created opportunities for people to hold a device in their hand and participate in a global community. But we had centralized ownership over data and organizations like Facebook and Google and Amazon, or in Africa now, Jumia, were earning a lot of money by being that central marketplace or central hub. But what they were not doing, unless you were a shareholder, is they were not actively allowing the participants to gain value. In Web3, we're moving to a space of read, write, and own. And what's exciting about that is, again, if you have internet access and you have talent and you are an innovator, you have the opportunity to jump into this global marketplace, whether the financial constructs were originally designed to include you or not. That, to my mind, is disruptive. I mentioned that I'm a mom, and one of the things that really matters to me on a very personal basis is thinking about women and girls in the developing world. I believe that to whom much is given, much is required. And so I think about the talents and blessings that I have as an intellectual property attorney, and I'm considering how can I pay that forward and try to create and support marketplaces where the internet can create an opportunity for people to participate and have better education, better financial means, more interactive communication with people all over the world. And that, again, is what is exciting and promising to me about Web3. I don't want to presume that everyone who's joined us has a baseline in intellectual property. So I'm going to step back quickly and just give you a sense of what I'm talking about when I say that I see all of Web3 as intellectual property. So you've got trademarks, and those are going to be, that's an umbrella term for brand names, logos, and slogans. So hopefully everybody's familiar with Nike, right? And so the name Nike is a brand name. The swoosh is their logo, and Just Do It is their slogan. So all of that is trademarks. In a Web3 world, Bored Ape Yacht Club or Women Rise or World of Women, so many of these NFT collections have brand names, and that's how people are able to identify them and know that they are participating in a community, not only by the similarity of the digital assets, but by the branding that's overarching that set of assets. So trademarks are one type of intellectual property. Another type of IP that's really relevant in the Web3 space is copyrights. And so the way that we protect the creative arts, be it music, books, sculpture, photographs, all of that is protected under copyright. The nice thing about copyright here in the States is that you can get a registration and have protection for copyrights for less than $100. And why does that have agency on a larger basis outside the United States? It's because there is a convention called the Berne Convention that allows you to get a copyright registration in one country and have protection that expands beyond that geographic region. So when we're thinking about concepts like NFT collections, where you have purchasers on a blockchain all over the world, or when you're thinking about things like the different types of software as well. In blockchain technology, the software tends to be open source, but software can also be protected under copyright. So of course, there's also patents and trade secrets. But when we are considering things from the perspective of the Web3 space, trademarks and copyrights are going to be critically important. And helping your clients, when you become attorneys, think through what does that look like? What kinds of protections from an intellectual property perspective are going to serve my clients? And why is that important? Because we want to help our clients build wealth. And one of the ways that we do that in a digital age is to build a portfolio of intellectual property. So a lot of times when I'm talking to creators and projects, one of the first things that we're talking about is, what does your roadmap look like? If you think about the Bored Ape Yacht Club, that's a real expansion from an intellectual property licensing perspective. The traditional paradigm, particularly here in the United States, is Disney, where a central corporation owns all of the intellectual property. And you might get in trouble for doing something like, for example, creating fan art. I personally like Winnie the Pooh, right? So if I had the talent, which I don't, to be able to draw a new derivative of Winnie the Pooh, and I tried to go sell that, I would actually be infringing Disney's rights on that property. But what Web3 has done is it shifted the paradigm to allow those participants and buyers of NFTs to have certain commercial rights. So we go from the Disney paradigm, that's the traditional legacy lockup, we own all the IP, you better not use any of it without our permission, to in 2017, 2018, we got Cryptokitties. And what that did through Dapper Labs was it created an opportunity for NFT holders to start to get to do something with the assets that they were buying. As was mentioned before, the holders of those NFTs got the chance to go out and put them on t-shirts or mugs, or think about ways that they could take that asset and use it as leverage to build revenue by commercializing it, right? So that was a step forward. Then we got the Bored Apes example. Recently, earlier this year, they also purchased CryptoPunks and Meebits, and they gave an even broader commercialization license, right? And all of these licenses that I'm speaking to are contract law. So we again moved the paradigm forward where there was no commercialization cap. And then the most generous example is Creative Commons Zero, where when you buy an NFT, then you get the right to effectively use it without any restriction and without the threat of that license being evoked. But remember what I said, there's more than one type of IP at issue. You've got the brand. And so you might buy an NFT, and in that, depending on what the license looks like, you might have the right to go commercialize. Let's say, for example, with Bored Apes, people are building music bands where the face of the band is their ape, or they're building cartoons, or I think it's in California, there's actually a Bored Ape restaurant where the ape is the image or the logo for the restaurant. But it's important when you are buying NFTs to be thoughtful about the scope of rights that you're taking on. What are you buying? Are you starting from a baseline where under copyright law, all you're really getting is the right to privately display and resell that NFT? Or are you getting a much broader right where you can commercialize? Creators and artists and photographers have not historically thought about all of these intellectual property issues from a digital asset perspective. So you as law students, as was mentioned before, you have this extraordinary opportunity to understand Web3 and be able to educate a whole new opportunity, a whole new turn of the internet, and on a global basis around how to commercialize those assets. So going back to just the tent poles of Web3, you've got cryptocurrency, which is our financial baseline. You've got decentralized finance, which is a whole ecosystem of financial systems that allow you to do things like earn extraordinary yields on stable coins and other cryptocurrencies. Whereas here in the States, traditional banks are paying very, very low yields on the US dollar. You've got NFTs, as I mentioned, which are very intellectual property based. You've got DAOs, which are the community. Oftentimes, NFT communities are represented as a DAO. DAOs are opportunities for financial investments, for supporting innovation in new protocols in Web3, for social good, for issuing grants and charitable purposes. There are any number of ways that DAOs are creating new opportunities to build community, and really community and culture are the cadence of Web3. And then of course you've got the metaverse, and anybody who tells you they have that figured out, they don't. And so jump in, the water is warm, feel hereby empowered to take your brain trust and create opportunities in law for people to be able to better understand how to capture meaningful value in the metaverse. So I hope that gives you a sense of why this matters to me. I invite you, I welcome you into the legal profession, and specifically this wonderful niche that is Web3. I invite you to ask us questions. This is a wonderful opportunity. I'm learning from the other panelists, and I look forward to hearing the Honorable Harvard professor share his thoughts.
Okay, thank you very much. That's a very, I'm just a lecturer over there, not a full professor, to be clear. But I think, what you kicked off with, Joanne, and hey everyone, my name's Mayman Woodyway. I think what you kicked off with was really the most important point, which is that you've got to get your feet wet. And, I think it goes with Nicole was saying before about how this is a space in a traditionally hierarchical profession that is, uniquely amenable for younger participants and younger professionals to excel, right? It's, with law, your first year associate, your second year associate, how long you've been there is literally your title. And so typically being around for a long time, is a boon. But here, by being younger and actually engaging with these technologies, and, reading about it is one thing, but, make a MetaMask, right? Buy an NFT, right? Trade some crypto, go on a decentralized, these are the kinds of experiences where, your older colleagues will be reading it, but if you're not going to understand the value of a picture until you spend $200 on one, right? And so actually kind of diving in and getting your hands dirty, I think can be one of the most important things, because so much of the legal aspects of this are still theoretical. I actually did not practice law, though going to law school, I never took the bar. But one thing I did where I think it's valuable for this session is that, I'm part of an ownership group of the African Museum of the Metaverse, right? And I think this is we've bought land and have museums across multiple metaverses, Decentraland, Sandbox, not that close to Snoop Dogg, but we're around, crypto voxels, etc. And we have, lots and lots of African NFT art in there as well, right? And I think I do want to give you a little bit of a tour just to kind of show you what it looks like, but really just also to tell you how something like this, which is an entity in itself, over the land itself that we have is worth over $150,000, and the NFT art that we've amassed from African, creatives is over $70,000, right? But this was all done without any formal, any IP, any kind of doing a corporation, because it happened in the metaverse, right? And so, I think to take some of what Joanne was talking about, and can you guys see my screen?
Yes.
So this is the African Museum of the Metaverse Crypto Voxels location. And we can go in and see the art. But I think from the outside, I was actually, hearing you talk, Joanne, was fascinating, because when we think about our organization, right, with the group that owns it, our investor group, it's a .eth domain, right? It's blacksanta.eth. And we bought blacksanta.eth, and now we own it. And, our logo, it's because it's Black Santa, is a shack. He gives back 4258, because he had an NFT project. One of the very few of the 10,000 did he actually have both the Santa hat and the Santa shirt were both separate kind of particular entities. So we snagged this and kind of made it our logo, because to your point, it's an image. We didn't have to go to trademark office because it's on the blockchain that we own this image, right? We didn't have to go and open up a bank account, because if you send money to blacksanta.eth, it will come to us, right? We also own africanmuseum.eth and kind of things like that, where we've got alternate accounts to kind of be able to raise funds, right? And so in a world where you can erect a structure, right, create an identity, create a logo, and actually own it, all without engaging with the government, and all kind of just doing it through different kind of smart contracts on the blockchain. And I never really thought about what we did as that, but the way you framed it, Joanne, that it really is what it is, right? You're able to kind of go and create something. We have, thousands of visitors in here, right? We've hosting many events. We just did an event for the Thurgood Marshall, College Fund out here in the US, where HBCU students, we kind of went around and kind of showed them and taught them. But, for all the different NFTs and artwork here, as you guys know how NFTs work, when you click on the artwork, you see exactly who owns it, and you see exactly who created it, right? Because it's an NFT and it's on the blockchain, right? And so once again, you don't need a deed of like a piece of paper that's behind you that you're going to go to court about, right? You would never go to court, right? Because it's on the blockchain, exactly who owns it, exactly who creates it, right? And so you're able to, create these things, do these transactions with people across the globe that would typically have lots of red tape, because it's difficult for people who don't know each other to transact with each other without a trusted third party. But, as I think, framed very well, the blockchain allows, different parties to transact without a trusted third party, right? And that at its core is kind of the incredible difference it brings, because it allows folks, you don't need to have a bank, you don't need to have any of these centralized things that our entire societies have been based on for hundreds of years. You can just go out into a metaverse, collect art, erect structures, create domains, and begin to kind of work with all these people in this world outside of kind of some of the traditional things that you see. So that kind of clicked for me today, and kind of seeing everyone's different presentations and stuff. And yeah, I'm happy to talk more about kind of this experience as well. And yeah, that's all I got. So I know, Nicole, it's like you had a question. I think we probably dive in.
Yeah. So just a comment regarding the crypto transactions, like when you buy an NFT, like a shack, and you put it in your museum. What I've found very interesting is that I think we all know that in order for a contract to be valid, both parties have to be of age. So here it comes. How do you know that someone is of age in the blockchain? You don't have credentials, you don't have social securities, you don't have an actual name for that. So you're not even John Doe, like at the minimum, right? So there's just another legal issue that I've seen, not often, but it's there. Like, okay, I buy you this shack and then I donate it to your museum, but guess what? I'm a minor. So, I mean, I could just back off and okay, then what do you do about it? You don't even know who I am, but then you figure out that I'm a minor. So you're out of luck, and then you're out of luck again.
Yeah, I think it will be an issue to address the pseudonymity or anonymity of blockchain. When this was created was by an idea of cypherpunks that wanted to be that were very libertarian, and they wanted to be away of a specific country's jurisdiction, because sometimes or always the libertarians think that the governments are always treading on them. They are always in the way of some kind of development, personal development. So the whole idea of blockchain started from there, from a cypherpunk perspective, from a libertarian perspective, to be outside of the system and to work and make transactions and to deal with wealth and make store of value outside of any kind of governmental jurisdiction. But I think that with the whole acceptance of blockchain and cryptocurrencies throughout the world, we will need to address some key issues as to protect less tech savvy people that want to enter into the blockchain and the cryptocurrency world. So one of them is digital ID. It's somewhat problematic to do it in most times, most of the times, but I think it will be a necessary measure as to prevent what Nicole was saying, to be dealing with someone that is not allowed in the traditional set of rules to do something, because they can't dispose of their assets in the way they want, or they are disposing of something that is unlawful. So we'll have to tackle that in some sort of way. Normally, we put that encumbrance on platforms to do that cross-checking before we do something. But a lot of times, the interactions with smart contracts can be made directly with the smart contract in a peer-to-peer transaction. Between parties, or with a smart contract in the middle, governing all the rules between the parties automatically. So in most of times, the platforms are only graphic user interfaces as to someone to operate and to call functions on a specific smart contract directly, or indirectly in this case, because they use the platform as a user interface to make those technical function calls directly to a smart contract and to operate them. So yeah, the European Union is already trying to address that and to tackle some key issues regarding know your customer and know your transaction as well, to identify or to block funds from, let's say, sanctioned countries like Russia nowadays, Iran, or other countries that are sanctioned by the OFAC. Or by the European Union as a whole. So I think with the greater adoptancy of blockchain, not blockchain, but cryptocurrencies as a whole, as an industry, as a parallel industry to the legal and traditional banking system, because with fintech, it was another layer above the traditional banking system and the traditional fiat money system. Cryptocurrencies are a parallel system to the traditional banking system. So it takes it actually takes away the wealth from one system to another, the value from one system to another, and that brings a lot of changes in the world economy that need to be addressed. So knowing the transactions, knowing the customers, knowing who is on each side of a smart contract or a transaction. It will be very important to address and to tackle as to prevent some unlawful activities. Yeah.
I would just add to that it's a known issue. I mean, here in the States, we've had the Children's Online Privacy Protection Act in place for quite some time, but digital identities are frankly just difficult, especially when we're trying to find common ground with ever evolving privacy laws. And privacy laws that have long arm reach across jurisdictions and across states, countries. Also, because we live in a world where people want to be able to change, for example, their gender identity, there needs to be space for the complexity of identity. Also, here in the States, because we live in a society that has more wealth than other parts of the world, children might have their own device. In many other parts of the world, children might share a device with an adult or someone who is at least older than them and more mature, more capable. So it's really difficult when we're dealing with avatars, when we're dealing with people who have multiple devices, when we're dealing with the reality that children have their parents' passcodes. When we're thinking about, a blockchain technology, a digital wallet is a sophisticated thing right now. The user interfaces are not easy at this point. So unless it's a pretty tech savvy kid, they're not likely to have their own digital wallet. But let's say they're doing something on Roblox, they're asking their parents to be able to give them financial resources to be able to do certain things in game. So I think it's really like so many other aspects of the digital economy. It's going to require legislatures and governmental authorities really paying attention and listening and evolving with the technology, because I can certainly speak to the fact that the law here in the States moves much more slowly than the innovation. And as a parent, I absolutely want children to be protected from things that are not appropriate for them at certain ages. But the reality of trying to, for all the reasons that I just spoke to, the reality of trying to identify someone as a minor is really difficult. It's possible that there are technological solutions that will help, but I can't say with confidence that we're there. It's terribly difficult. And there's some component of it where we just need to rely on adults like parents and guardians to try to help be gatekeepers for children. There was also a question that was directed to me in the chat, asking about the criticism that cryptocurrency services take too long for transactions to settle and sometimes has high transaction fees, and why some countries do not regard cryptocurrency, but then it kind of cut off. So I will say that while I'm a digital assets attorney, my focus is not in the DeFi or crypto space. I'm very aware of those.
Uh-oh. Let's see. Did I come back there? Can you hear me?
Yes.
Yeah. We lost you just for a brief second.
I think you're good now, Joanne.
Okay, good. Thank you. AirPods got tired and gave out. So what I was saying is, one thing to keep in mind is that there are several different blockchains, right? So the one that people tend to be most familiar with, if you're not in this space every day, like the four of us on the panel are, is Bitcoin. That's merely one blockchain. Another blockchain that folks might be familiar with is Ethereum. And Ethereum, because of its popularity with developers, there are a number of dApps that are built on top of Ethereum. And so the gas fees to have nodes around the world confirm transactions on the Ethereum blockchain can be expensive. There are a number of solutions that are underway. So there are alternative layer 1 blockchains, including Avalanche, Solana, Near Protocol. There are other, again, what a layer 1 blockchain is an open source software platform that transactions and dApps are digital apps that are built on top of blockchains. And so when you have a very popular blockchain like Ethereum, sometimes the gas fees or transaction fees are going to be higher. But again, there are solutions. You can choose to build and conduct transactions on Solana or Near or Avalanche. I would suggest when you are thinking through those things, be careful about the integrity of the protocol. As is mentioned before, do research and be extremely careful in any links that you click on. I think it was mentioned earlier, reputable places like CoinMarketCap and CoinGecko will give you the exact link. Even if you are in a Discord, be very careful about clicking on links, even if you are finding it from supposedly a social media account that should be reputable. Check and double check. I mean, I am in this space for a living and I am paranoid about any links that I click on, anything that I open my digital wallet to, and that is for good reason. There are scammers out there and you want to be careful. If you need to be on the Ethereum blockchain, there are also things like Polygon, where it is a companion to Ethereum and you can have much lower fees. So doing a little homework about reputable ways that you can manage those blockchain transaction fees might hopefully start to address some of your questions. In terms of it taking too long, it depends honestly on the blockchain. There's a balancing between security, I'm not going to get into the quandary, but there are some issues around security, speed, and cost. And so there are blockchains where things move very quickly. It's an issue of how many nodes there are globally to be able to manage that. So I'm going to pause. There are many other experts on these issues on the panel, and they, I'm sure, will have meaningful thoughts around this as well.
So I'm looking at the question panel. I have a question from James. I'm not gonna butcher your last name, just James, which is, it reads, what are the major challenges Metaverse is facing and measures to put in place to solve them? So one of them we just touched bases is based on is identity. Like if something goes rogue, if you get defrauded, if you don't get that utility or that product that you purchased from, there's a very big challenge to identify who that person is. And you, most of the time you're out of luck, like you just lost your money, you know, take your loss. With high risk, there is also a high reward. So you may be able to do a really good deal, as you may also be able to lose a good deal of money if something doesn't pan out. The other issue is jurisdiction-wise. I practiced as an international arbitrator for a couple of years before. And when it comes to jurisdiction in the metaverse, just like jurisdiction is an issue in arbitration, when it comes to forum selection or venue, in the metaverse, you have different parties from different parts of the globe. And sometimes when you're able to identify them, you have a venue issue where you say, okay, Nuno is in Portugal and then Joanne is in the US. They both transacted in the metaverse. So both transactions came, one from Europe and the other one from the United States. What jurisdiction do you apply? There is actually I think, if I'm not mistaken, the American Arbitration Act has had some opinions regarding what jurisdiction to choose. I think also some conventions have had brief opinions as to how to go about those jurisdictions, how to choose the venue and forum selection. But that's something for a different panel. But that jurisdiction and identification of the parties are two big things to look after in the metaverse, because we're not transacting here with $100. These are thousands and millions of dollars that we're talking about in a virtual reality that none of us are familiarized with, and we won't be until a couple of years from now. No one can say here they're an expert. Just, I would say some of us know a little bit more than others, but in reality is that you know more about the metaverse, I know more about the DAOs, you know more about DeFi's. No one can really claim they're experts because it's just too new. And then I have another question here.
Nicole, before you leave that, maybe do you want to discuss the terms and conditions of a metaverse world and how that could potentially apply as well?
Yeah, that is important, because normally when you access Decentraland or the Sandbox metaverse platforms, usually you have terms and conditions that apply, like a set of rules or a contract between the platform and the users of the platform. So normally the settlement of any discussion or argument between the parties that interact with that platform are set in stone in those terms and conditions.
Yeah, and just to add there, you know, that's important because a lot of these metaverses, yes, they're built on the technology of blockchain. You log in with your MetaMask, they are, you know, on the blockchain, but they're oftentimes private companies themselves, right? They're kind of building these worlds. Sometimes there are DAOs as well, which of course gets just as all the messiness we've talked about, you know, before, but, you know, they will have, but I mean, as someone who's read a lot of these, they're not always the clearest, and you can tell a lot of times they have not thought of all these different potential scenarios we've been talking about today. So even with the terms and conditions, there could still be some gray area.
Here's a question that Nuno, if you don't mind to chime in. It says, comes from the Lasco Association. Is Metaverse merely speculative or a reality? How do courts update their rules regarding Metaverse issues?
Sorry, where's the question?
It's sent at 12:16 p.m. from the African Law School
Metaverse
African law students.
Yeah, well, the metaverse exists as long as you can see it or experience it in some sort of way. It exists. It's not a dream per se, or an intellectual creation. So you can interact in the metaverse. So I believe it's a reality. To answer the first question, you have a set of rules to operate within the metaverse. The metaverse it's a very broad term because you have different platforms on where to have access to this metaverse. So the metaverse is not an ethereal concept. It is accessed by a specific platform. We had for a long time ago the Second Life game, which was a game where you can add an avatar and live a second life, a virtual second life, literally. And all the MMORPG games like World of Warcraft, where you can have and interact with other person in a metaverse. The difference nowadays is that with the advent of blockchain and crypto assets and with NFTs, you can have your own property inside that metaverse. You can have your own assets, you can have your own transactions, you can make your own money in the metaverse. So the difference is there because back in the day, all the assets belonged to the company, to the IP owner of that platform, of that game, of whatever it was, where you interacted with other human beings. If you wanted to make any kind of transaction, it would have to be a real money transaction or something with real value in the real world. You had to do it outside of the platform, typically violating the terms and conditions of the said game or the said platform. So nowadays in the metaverse, you can have that second life as well, but you can transact and you can see the real assets owned by real people, even though they are just avatars as well. So that's the main difference between what we have and what we have now, because nowadays we can have digital value that never leaves the digital world, being transacted in a global way. That was the beauty of the blockchain and the beauty that Bitcoin brought to us. And after Bitcoin, every other blockchain that came afterwards, the Ethereum blockchain, the Solana, the Cardano, every other blockchain where you can have any kind of token or ERC20 compatible token running on top of that. So that's for the first question. How the courts update the rules regarding metaverse issues. There are still, at my knowledge, that there are still very few cases where these questions are being discussed. Even in the United States, which was the first country in the world to address these issues on a judicial way. But I think it's too soon to address these issues. Recently, I had a case where it's not regarding metaverse, but I had a case where I had to ask a judge here in Portugal to send a restraint order to an exchange in Korea because someone had stole funds from a client of mine. They worked on the project. They had access to the private keys of the project wallets. They subtracted the tokens from the project wallet into their own wallet, and then they tried to sell those tokens on a centralized exchange in Korea. The beauty of blockchain here is that you can watch everything happening in real time at the second. You can go to Etherscan or to any other platform that allows you to see the transactions being made, and you can pinpoint the transactions and detect where the funds went. So my client did all the first work, and I had to adapt what happened, the factuality, and to give those facts to a judge, and the judge, abridged by international conventions regarding cybercriminality, they addressed that issue, and the centralized exchange blocked the account and made the funds available again and transferred the funds to my client. So yeah, I believe we have a judge in this case, in this specific case, addressing an issue. It's not Metaverse, it's only the token transactions and an unlawful transaction. But I believe Nicole, Joanne, and Mem also brought good points regarding this, especially Nicole, regarding how can a judge address questions of IP and NFT transactions. It's very hard nowadays to have specialized judges analyzing all these issues. We're having a lot of side noise.
There you go.
Okay, yeah. It's kind of hard to have a judge that understands all the intricacies of Metaverse, of NFTs, of blockchain, and to address these issues. But it's a practice that they will have to develop, and it is better to develop those practices with specific regulation and specific legislation and laws upon which they can decide on a specific case. Because if you have no regulation, a judge can't do much without the law to apply to a specific case. So if you are unregulated, it's kind of hard to have a judge to adopt some laws that were made sometimes 50 or 60 years ago to address a specific case. We have that happening with the SEC and Ripple, because they are applying an AUI test to something that was, the AUI test was created in 1933 in the United States, and it's still holding nowadays to analyze something that is completely out of question regarding the time that test was created. So we are using, how do I say, we are using legislation that was not prepared to evaluate or to analyze the cases that we have nowadays. And it's kind of hard for a judge to do that.
You know what's interesting about the Howey test, Nuno, is that I think, if I'm not mistaken, I read that the Howey test hadn't been used for like years, like so many years prior to this new era. So it's interesting to see how this law that it goes way back is now being used to analyze cases that are so forward from what the actual legislation currently is, right?
Yeah, so they revived the Howey test.
They pretty much revived. They brought it from the death because they weren't even using it.
Yeah.
What's also interesting is you can apply it in very creative ways that can. I've heard arguments that if you have a roadmap for an NFT project, then it's a security. And if you think about it, okay, so you are buying something or offering something of value for the purpose and expectation that its value is going to increase based on the efforts of others. So if a creator is creating an NFT collection, people are paying to buy into the collection with the expectation that it's going to grow in value based on the creator having had a roadmap. I mean, that seems like a very strict interpretation of Howey, but I've heard many attorneys in Web3 say and we know this, right? This is the thing you learn first year of law school. There is no law. There's only interpretation of law, right? That's why it matters so much who's on the bench. And I think about this and I think, man, that's a really hard standard, because then you effectively are telling anyone who issues a token, anyone who's leading a DAO, anyone who's an NFT creator issuing a collection, if you say anything about the value appreciation of your collection or your token, or historically how assets or projects that you've been involved with have appreciated in value, you're opening yourself up to an unfavorable Howey interpretation. And I find that frankly really challenging when I'm asked about, well, is there any safe haven for having a token? And I'm like, well, first of all, you want to make sure that you're thinking through the Howey test, but also I'm kind of saying stay away from any discussion of financial appreciation. Try to focus in the spaces of governance and frankly, cosmetic governance. Stay in the spaces of social access to community. Stay in the spaces of opportunities to buy products or services, maybe first in line kind of thing. But how do you just completely dodge any conversation about financial value of digital assets? And so how are others, I mean, I know I'm asking my own question here, but how are others thinking that issue through when it comes to NFTs and tokens and trying to stay in some kind of Howey safe harbor?
And Joanne, these questions that you're making to yourselves are pretty much our everyday questions, because there's no precedent, there's no clear guidance from the legislature, and this is how Web3 attorneys practice law, making hypothetical questions that have no answer, no guidance, no precedent. So we're here becoming creative attorneys now. We're trying to get very creative to be able to work things like the Howey test. And then to add an additional layer is, you know, NFTs have an added value, but they can also depreciate. So the extra layer comes with the FTC when they say, okay, but you know what? This is now defrauding the customer and the investor because you're being too speculative about their investment being something that will either add value or lose value. And there's no way you can determine that. So that's an extra layer on top of, you know, passing the Howey test. You also have to pass a test on, are you actually defrauding the investor? How can you tell if the people who are buying the NFTs are actually investing or not? Like, you know, where do you draw the line? And of course, we put disclaimers and whatnot, but that's where we're at. We're in a uncertain law practice type of thing.
Yeah, I believe there's more discussion regarding these issues, and I believe the participants have been very, very thrilled with the back and forth response coming from our guests, and it's been very educative. And I'm sure they really want to continue on this section because, like you all said, it's a very novel, way of life that we have to find a way to get on board. And we are hoping that these, practices can see the light of day, which they are very novel. But we will definitely see how we go from there. Want to thank every guest who have been on this section. We just have about 8 minutes to go. And truth be told, I, for one, there's a lot of, information that I've gathered from this discussion that I wasn't aware of. And so I believe also the other participants, they have also benefited from it. So we're certainly going to continue these discussions on NFT, the Metaverse tomorrow. We have other guests who will be coming to the program tomorrow. But I want to say today's section has been very wonderful. I want to thank our guests today, Joanne, Nuno, Meme, and Nicole. You guys have been wonderful, giving a very expository analysis in terms of this novel, concept, especially when it comes to the law and technologies. So I want to give it to the Vice President, Madam Chiere. I believe she has one or two things to say before we round it up. Chiere, are you there?
I think she's not. She's not in the participant.
In absence of Chiere, I will invite the Vice President of Administration of the African Law Student Association to also give us our, final words. Mr. James, are you there?
Yes, please, can you hear me?
Yeah, we can hear you.
All right, that's fine. Thank you so much for the opportunity, Mr. Prince. It's a pleasure to be called upon, to say with so far this webinar. Day one is concerned. I didn't join early. I joined the middle of the presentation, and I must confess that it was very insightful, and I've learned a whole lot of things. And I'm looking forward to day two of the event. And much appreciations also goes to all our presenters. We really cherish you out of your busy schedules. You've dedicated yourself to educate us on this particular topic. We appreciate your effort and everything, and we look forward to having future relations and engagement more with you so that we can be more versed in this particular novel topic that we just had. So thank you so much, and we are most grateful. Thank you.
Thank you.
Yeah, once again, thanks to all our guests. We are hoping that next time, if we have such events where your expertise will be needed, we'll definitely want to call upon you to be part of this novel association. So we will be rounding up this program. Thank you all, and have a wonderful day.
Thank you for
You
having
too.
us.
Thank you.
Bye.
Nice to know everyone. Bye.